I once had a student tell me, "Why do you talk about the exam so much? Because it really drives me nuts. You increase my stress factor immensely." And my response to that was, well, mission accomplished then. No, if training isn't miserable, you're not proud of having survived it. So, with that in mind, let's begin our discussion of Federal Rule of Evidence 804. And 804 is the section of the substantive evidentiary law that deals with hearsay exceptions where you must establish as a condition precedent to making the argument that the declarant is not available. That is the first thing that must be done. So what is helpful to us is to understand exactly what unavailability means. And if I start to take a look at the rule in the definition of unavailability, well, we see some things here. There's a category of examples of how unavailability happens. And unavailability does not mean death. Although you could think of it in your head as legal death, in that by operation of law or by operation of fact, the person is not capable of testifying. And that's what the definitions of unavailability in 804A are all about. And if we look at them, privilege, an assertion of privilege. We talked about privilege earlier from a spousal or a marital perspective. There are other types of privilege that get applied at the common law that could result in a witness not being allowed to testify, making them unavailable for purposes of hearsay rules. Any of the common privileges, attorney-client, priest-penitent, would be examples. So the assertion of privilege, the most common one, quite frankly, from an evidentiary perspective, is in a criminal case where a witness asserts their right against self-incrimination and refuses to testify. And that's a Fifth Amendment privilege against self-incrimination argument. How many of you have had federal criminal procedure already? A few of you. It's the Fifth Amendment right or the Sixth Amendment right to counsel. It could be either one of those. Those of you who haven't taken it, if you're trying to decide whether or not to take federal criminal procedure as one of your courses here at the law school, I'll give you a couple of statistics to think about. Over 50% of the criminal law questions on the multi-state bar exam are actually constitutional law federal criminal procedure questions. They're the Fourth, Fifth, and Sixth Amendment, Fifth due process, and the 14th due process. So even on a required course, you want to be in a clinic from the standpoint of actually understanding substantive criminal law for purposes of the state bar exam, a study of federal criminal procedure, not the statutory rules of federal criminal procedure, but the constitutional amendments is downright crucial, as long as you take the right professor. Now, and I won't comment on anybody else who teaches it. Most of the folks who teach it do a great job. Have someone who can't assert privilege, because the privilege does not exist, but when placed on the witness stand, won't testify about the issue in question, even when held in contempt by the court. The classic example of this, by the way, happens to be reporters. You do know that no privilege exists at common law preventing a reporter from disclosing their source. There is no common law privilege of reporter source. None. Does not exist. In fact, after this issue came up in federal courts, what we saw as a response was the passing statutorily in many states of protection for reporter sources. But if you're not in a state jurisdiction that has a reporter source privilege, they can be forced to testify. Well, sometimes these reporters refuse to do it anyway. Sometimes people refuse to testify because of the personal relationship with one of the folks who they have been called to testify against. There were folks in the Paula Jones trial against President Clinton who refused to testify and spent years in prison because they were held in contempt, because they would not testify in that particular trial. Well, if that happens, and the court determines that happened, I can use previous statements as they've made potentially under 804, if I can put it in one of the right categories. What else? When they lose memory. If you lose memory in a way that makes you no longer capable of retrieving the information, that's going to be enough. And of course, we can think of all sorts of ways that those sorts of examples could be thrown out there. Unable to be present to testify because of death or a then existing physical or mental illness or infirmity. So if I'm dead, I'm unavailable. Statements that I made when I was in fear of death are separate from the initial requirement of unavailability. So I want you to keep those in separate mind. Just because someone is dead now doesn't mean that I can use 804 to admit their statement. Death is rather one of the ways that I establish unavailability. I can be physically unavailable. Classic example is you're outside the jurisdiction of the court at the time that you're subpoenaed. It is an ethical violation, of course, to suggest to witnesses that they might want to take a trip outside the continental United States during the time that you know a trial is pending, when they have evidence that would hurt your client. You should never suggest that. But if they were to decide to do that on their own, they would be outside the jurisdiction of the court, making 804 apply to them. You can also have 804 apply when you're physically present but mentally not present. And that can be from a traumatic brain injury, hemorrhage, anything that reduces or destroys your ability to recall the information previously. That makes you unavailable for purposes of 804. Are you thinking? Do you have a question, or are you just thinking? Okay, all right. The court makes a finding that you're not available. Now, that's not normally does not require an expert. You'll have an offer of proof by the party who's attended the out-of-court statement, and if that's not in controversy, the argument doesn't flow around whether or not the person is truly not incompetent. It almost never results in an expert witness type situation, because usually 804 deals with, for the most part, what is involved in the litigation, but not the parties involved in the litigation. Because parties generally flow into the 801 category for the exceptions, and so we don't find ourselves turning to 804. Question?
Okay, I have a question. This is going to be kind of off the wall, but if you had, say, a insane person react something that is solved, would that fall under 804? Because they are crazy, but they're reacting what they saw. They keep doing it over and over again.
If we think about someone who doesn't have competency to qualify as a witness under the 600s, such that the judge would not allow them to testify, if I can't place them under oath and they can't be subject to cross-examination, 804, while it might potentially fix the hearsay issue, it doesn't fix the competency issue of the witness. So even if I could apply it, it's not going to matter because I can't get over the other hump. Now, that said, a creative advocate would think in terms of recasting someone with that severe degree of mental retardation or mental infirmity and compare them, rather than to a person, to some sort of machine or device or even animal that responds to a certain stimulus in a certain way. Then you might be able to get that evidence in for what it's worth. But we're talking, you're walking out on the limb if you're doing that. Not as much a hearsay question as it would be a competency question. And you folks do realize, of course, that insanity in and of itself does not make a person non-competent for purposes of testimony. Neither does mental retardation, autism. There are all sorts of mental diminishments that do not result in lack of competency under the law, just like you can waive your constitutional right to remain silent even if you happen to be for Cocoa Puffs. Mental competency is not the only question that gets involved when we're looking at that from a law perspective. But, both physical illness could work as well. If someone's in the hospital, if someone's incapable of enduring the rigors of testimony because they're on chemotherapy or whatever it might happen to be, it's very fact-specific. If you got a multiple choice question on this in a bar setting, you need to look for the things that they do in the call of the question that support an argument that the witness is infirm such that they can't testify to cue in an 804 exception. Now, if we look at the last one, is absent from the hearing and the proponent of a statement has been unable to procure the declarant's attendance, the declarant's testimony, or by other means. What does that mean? It means that the person's there, they're not there, and the witness, the side who wanted to call that witness, has taken the steps that would normally be required procedurally to produce a witness in that jurisdiction. So, for example, if I want a witness to be called as one of the parties in a case, because I want to call them to testify, and they don't show up, I can't use the 804 declare it unavailable exception if I haven't properly requested them as a witness or asked the court to subpoena them, or if I have the ability issued a subpoena myself, because the subpoena is the means by which the court enforces attendance. And without the request for the subpoena, they're not really unavailable under 804. The answer is we don't know. So when I had witnesses that I know are going to be unavailable, I make certain I put them on the witness request list, particularly if I'm the criminal defense lawyer and I don't have the responsibility for producing witnesses. That responsibility resides with the state. So I'm going to put them on my witness list. I'm going to request that they be produced, and then when the state can't get a hold of them, I'll use 804, if possible, to admit the statements that I need. It's there to make clear that you must follow the procedural requirements of the jurisdiction in question to request or to produce witness, that you can't play games with witness production in an attempt to get it over, to get one over on the court and get it in. Of course, Mudder Jeff have a question about how we could screw other people, right?
No, I really don't. But I do have a question. So, for the sake of our trials, I think we all have witnesses that are not allowed to be called for various reasons. Or maybe I'm wrong, but at least in our trial we do. What about to make sure that we took every reasonable means necessary to get in contact with these guys?
That's not going to be the issue. The issue is going to be whether or not there is evidence within the case file that establishes unavailability under 804 or that establishes the application of one of the other hearsay exceptions. That's going to be your question. You're not going to get this procedural argument in the magic world of 4-hour trials. It's not going to be a problem. But you'll get it in the real world all the time. You are presumed to have requested the witnesses on your witness list for your 4-hour trials, because we're not teaching you the civil or the criminal procedure methodology of doing that. Now, when you get into the real world, that's part and parcel of the process, right? But it's not required for trial act.
So you're saying that we should assume that if the packet says we can't call someone as a witness, that he's not on our witness list?
Well, no. If the packet says you can't call them, it's because they're not available to be called.
All right. So maybe we can make
Maybe you can make an 803 or 803 argument that something that they've said should be admitted.
Right. That's what I'm asking about.
Yeah. But you have to live with the facts that are within the packet and not create other facts to try to make it go that way. Why? Because these problems are balanced to create evidentiary and factual issues for both sides. The purpose of the 4-hour trial is not for you to beat the other side by winning the case. The purpose of the 4-hour trial is to crush your opposition by being the best advocate in the room given the facts that you have to deal with. If you want to screw yourself sideways from a grade perspective or a reputation perspective, the quickest way to do that is to try to find a trick in the packet that lets you win this make-believe trial in front of a non-real jury that takes place in 4 hours. That's not where your goal should be. Your goal should be that in 4 minutes where you get up and do jury selection, everybody in the room goes, man, I wish I could do that. And when you get up to do the opening statement, everyone goes, wow, I can't stop listening to that person. And when you do the direct, it sounds like a conversation. And when you do the cross, you crucify the person, pulling the wings off one at a time while everyone, no, that's not true. You make your point by properly developing your cross-examination techniques. Those are the goals. Don't lose sight of that in these 4-hour trials. I mean, routinely, I go the other way. I'm going to win. Victory shall be mine. And you don't actually win. And if you're in my trial act class and you do that, you go to the bottom of the grade pool, because I consider it to be an ethical issue in my group. Fight hard but fair, because at the end of the day, these are going to be the people that you're referring cases to in another 3 to 5 years. You don't want to piss any of them off yet. You want to figure out whether or not they're going to be against you, and then you will. All right, so this is how unavailability is defined, and it's the condition precedent to actually applying the 804 exceptions. So as I think about it that way, let's go through the 804 exceptions under 804B. And I'm not going to go through every one of them. I'm going to go through the ones that are interesting to me. They are interesting to me because they are the ones that I know shows up on the National Conference of Bar Examiners radar. This means they are the ones that are most likely to appear on the multi-state bar examination, which means they are the ones that are most likely to appear on my final exam. Former testimony. This is an interesting exception. It's got to be from the witness, but it doesn't have to be from the same trial. It can be from a different trial. It can be from a different time. The test is, was it under oath subject to cross-examination, which means it's either at another trial or in a deposition, and was there an opportunity and motive to develop the testimony on direct, cross, and redirect for the same substantive legal reasons? Doesn't even have to be the same attorney. See if I can give you an example to drive this home. Let's say we've got two folks at a theme park here in Orlando, and they're riding one of the rides on the theme park, and one couple is in the ride ahead of the couple behind them, and they get involved in a horrific accident on the theme park. They fall out of the roller coaster, they get drug underneath the log on the log ride, whatever the heck it happens to be. The couple in the first car sue the theme park. The couple in the second car sue the theme park. Now they're on the ride together. The first couple goes to trial and testify about what happened that day. You know, whether the sprocket broke and the thing came apart or whatever it happens to be, the causation that makes the theme park liable. The second couple hasn't sued yet. They win and then promptly get into a car accident and die. Now they're unavailable, right? Now the second couple who was on the ride files suit against the theme park. And they admit either the depositions taken from the two folks who were dead or a copy of their testimony at trial in their trial. The answer is yes. Even though it's a different trial, even though there are different lawyers involved, even if you'd had different lawyers involved representing the theme park. Yes?
So the only thing you need in that situation is just a common party to the suit.
No, it goes beyond party to the suit. It goes to the opportunity and similar motive to develop the testimony. And here's the key. Similar motive to develop the testimony can also almost be read as same or similar transaction or event. I made that one easy because they were both on the ride at the same time. What would make it harder? If they'd ridden the same ride on days.
That was what I was going to say. So say it's a similar event, just different times.
If it's a similar event or different times, now I've got to go to my argument under 804B. And what's the judge going to do? The judge is going to line those factors up, and then under 104, Federal Rule of Evidence 104, they're going to decide whether or not 804 would apply from an admissibility perspective. In the back and then up here.
What if there's testimony from an otherwise sealed court, either a dependency court or a juvenile court, that would be relevant in a civil proceeding? I mean, is that something that the judge would have to do in camera and would be permitted on record, or is that something that would be...
Well, the first thing that I would tell you is that you would have to go and look at the local rules of court, and you'd have to look at the statute that govern the process by which those records are sealed. Because those statutes normally have a procedure. The procedure, if we dies out to what's most common, revolves an in-camera review by the judge sometimes with the knowledge of the counsel who wants the statement, and sometimes without the knowledge of the counsel who wants the statement. And it's that judge's responsibility. Where would this come up quite often in the assertion of privileges? Let's say we'll go back to one of our case files here in class that we've used this semester, State v. Lewis, where there is a history of psychoanalysis or treatment of Ms. Tucker, the alleged rape victim, the prosecutrix in the case. If I'm the defense attorney, I'd like to see that information, to see whether or not she's made false allegations, to see whether or not there's been an issue with her in the past. I can't do that on my own. And when I do the request to get those, what would normally happen is those medical records would be reviewed by the judge in camera, and then the judge would decide. Some of it, the judge might not give me any of it, the judge might give me all of it, depending upon what's present. But I'd have to make that discovery request to try to get it. I'd have to have the state deny the discovery request, then I'd have to go to the court for relief, then that would kick in the review of those psychological records. And the way that actually works is our community, our society, asserts a value through the application of procedural rules. That's an example of how it happens, usually with children for sealed records, and also with evidence of that sort of medical treatment. Particularly interesting for us because there is a federal common law Supreme Court case, Jaffe v. Redmond, that says that you have a right to the privilege against the admissibility of your private medical conversations with a therapist if you're the victim of a sexual assault. You don't have that right if you're the accused in that sort of situation. So if you're the accused and you spill your guts to the court-appointed psychiatrist, every bit of that's going to be admissible. But if you're the victim and you spill your guts to the court-appointed psychiatrist, every bit of that can be prevented from being admitted through the assertion of the psychotherapist-patient privilege. And that's sort of a common law reflection of the same sort of thing that you're asking about with children as well. You had your hand up.
How is opportunity and similar motive, as I guess a standard, different from saying something like a causal connection? Are they different? Can they be thought of that way? Because I'm just trying to wrap it around in my head.
You can translate opportunity and similar motive to causal connection, but we have to be careful here because opportunity and similar motive are questions of intent, and causal connection is a question of action. When you say causal connection, I think of tort law and issues of duty breach causation damages. That's where my mind goes when I hear causal connection. Similar motive to develop the testimony on direct goes to the intent or the desire or the need of the lawyers who were involved. Think of it this way. Regardless of which lawyer it was, does that lawyer have the same need to ask certain types of questions? If they have the same need to ask the certain types of questions, then we're probably going to let this testimony in. So in the example where both of them were on the ride at the same time, well, yeah, that one's easy. If they rode the ride on different days, it might be more problematic, but probably okay. If they were riding different rides in the park and were both injured, there may not be that same need to develop a similar type of inquiry. So causation is a piece of it, but it's not the sine qua non, so to speak. What's really the thing that we're thinking about is what would be the intent of the lawyer in asking or not asking the questions. And the interesting thing about it is it doesn't even have anything to do with whether or not it's the same lawyer involved. It doesn't even have to be the same litigants, although usually one of the litigants is the same, but it doesn't have to be. And that's how former testimony works. It's much more nuanced than you might think it is to look at it from a rule perspective. That's why I like to talk about it. Any questions about 804B1? Cool. Let's look at the next one. 802, dying declaration. A couple things I want to point out to you about dying declaration right away. And the first one is the statement must concern the cause or the circumstances of the death, right? If they're not talking about how they got injured or why they're dying, it doesn't fit dying declaration. So, I love my children eternally and I want to make certain my son gets my Martin guitar, as blood gushes out on the floor. That is not a dying declaration. Might be a statement having something to do with testamentary desire, but it's not a dying declaration. So it's not an 804, it'd be an 803. Declarant has to be unavailable. Unavailable doesn't mean dead, although it can. And quite often in the multiple choice world of bar tests, they'll have someone who's unavailable, but not because of death, but because of some other reason, but yet you still got to sort through whether or not the dying declaration applies. And the key factor is the declarant's belief of imminent death must have existed at the time that the statement was made, regardless of whether or not they ultimately die. You'll notice that there's no requirement that the declarant actually die. Just that at the time they say this about why they think they're dying, they were under this belief of impending death. And the idea behind this, I'll get you in just a second. The idea behind this is that as we go back into the soil from whence we came, we do not want the last thing on our lips to be a lie. And it's founded in some very human concepts of higher power and life beyond this life that supposedly make it valid. This idea that we don't lie at the end of our lives because we want to depart to the next place with a clean slate. That's why this need for the belief of imminent death is a substantial part of it. There's one factor. It's got to be in a homicide case or any civil case. So if I'm in a criminal case and the person, it's not a murder trial, but an attempted murder trial, I can't apply dying declaration. It's got to be a murder trial. If it's not a homicide case, dying declaration does not apply. Now that's a bright line rule, right? So multiple choice questions often get set up to try to trick you into applying the bright line rule the wrong way, where everything will be right, but it'll be attempted murder and not murder. And the word attempted in the call of the question changes the answer. And if you're going quickly and you're not paying attention, you miss it. You could know the law and miss this question. It makes for a great little reading comprehension question, and so it happens quite often. Now, what else happens here in dying declaration a lot? They'll set it up in a civil case where the guy he'll make a statement with the fear of imminent death about how he got injured, and then he'll recover, and then die by a completely alternative means later on in the problem. And that doesn't matter. The dying later by a different means satisfies the unavailability of the declarant, and it's looking at what the declarant believed about their health situation at the time they made the statement. You had a question?
I just don't understand this concept. When do you have a dead person that is an available declarant? What situation would ever, I'm not understanding that. When they're not unavailable, but they are still dead.
You're not going to have a situation where if they're dead, they're going to meet the requirement of unavailability. But what I could have, I want to make the question hard. I have a guy, let's say he's driving a forklift in a factory, and something goes terribly wrong, and he knocks over a pallet, and the pallet falls on top of him. The cage on the forklift breaks, and he's severely injured. Severely injured. They back him to the hospital. He's lying on the bed, and the doctor comes in and says, "Man, you need to say your prayers. Do you want me to call a priest? Because you're done for. There's nothing I can do for you. You receive such massive injuries. It's not a question of if, but when your heart's going to give out. We're going to put you over here for palliative care. We'll give you a little morphine. We'll get your family here soon." Doc says this to him, and the guy says, "Those sons of bitches at the factory, I can't believe they didn't fix that defective forklift. We knew that cage was bad. We begged them to fix it, and that stuff crashed right through." He says this after the doctor has told him that he's dying. And then he gets fine. and his family goes to sue the forklift company. And he decides to take a trip to Barbados during the time frame that the trip is going on. So he's unavailable because he's out of the country. So we can't bring him in to testify, but he's not dead. If it's a civil trial in that set of circumstances that I just gave you, what he said to the doctor when the doc said you're dying would be admissible against the forklift company to prove that they were negligent in the way that they maintained the forklift. But he's not actually dead. That's why this question can be tricky from a multiple choice perspective. Because I can take that little scenario that I just spun out and just change one or two small facts, and you have to come up with a different answer. You can't come up with the right answer unless you fully understand the flow of the exception. Yes?
What if, same set of facts, and he gets seriously injured from the forklift and gets rushed to the hospital, and then the doctor, and he believes he's dying during the accident, and then the doctor operates on him, and it's because of medical malpractice that he died. Is that the alternative?
Well, if it's because of medical malpractice, then the hospital that is defending the medical malpractice claim might want to admit his statement on the dying declaration. And you'll notice that the dying declaration is not side-specific like an admission by a party opponent. Yes?
Will you be giving us, for the multiple choice questions, some slight delineation so we can see kind of what it might be?
I will test your reading capacity. I will test your reading capacity, which means that it might look on the surface like it's one thing, and sometimes it will be that thing. And other times it will look on the surface like that thing, and sometimes it won't be that thing. You know, if I ask you 4 dying declaration questions, you can bet your bottom dollar that they won't all be written the same way. And knowing that a third of the multi-state bar examination is hearsay questions, there's going to be a lot of hearsay questions on the multiple choice. And knowing that a third of the bar examination, by and large, revolves around relevancy and character evidence, there's going to be a lot of those. And the last third is primarily going to be made up with impeachment questions. The big 3 legs of the stool of evidentiary law that we've been sitting on this semester. That's really where all the points are. This will be some action trash in between, you know, a point here or a point there. But where you'll get in trouble is if you don't understand those 3 primary chunks of evidentiary law on the exam, because there's going to be a lot of questions on each. It's a good question. This one, once we look at it, where will I catch you? I'll catch you because you won't pick up about availability, or I'll make it a criminal trial that's not about murder. And I'll have the guy be dead. And I'll go, well, he's dead. He said it when he thought he was going to die, but it's not a civil case. It's an assault case or something like that. You just got to read with that degree of difficulty. That is, quite frankly, why the bar exam is so hard. It's not that aren't smart, excuse me. Yeah, Freudian slip there, right? No, it's not that you're not smart. It's that there's too much work to do in too short a period of time. That's why I teach this class the way I teach it. It's why I test it the way I test it, because I want to force you to get ready. It's been very effective over the years. It works very well. It's just not always a lot of fun for the students. Let's talk about declarations against interest for a moment. I mentioned declarations against interest yesterday when we did the big timeline of statements. We're trying to sort out how we might get it in one way or get it in another. A couple of things to remember about declarations against interest. I have to establish unavailability. If the guy's just testified on direct examination and I let him leave the stand and then I try to enter his earlier statement against interest, he's not unavailable. He was there to testify. The call of the question must give you the factors that establish unavailability. But if I have it, it's normally used not against a party, because if it's a party, what would I use instead?
Party opponent.
Admission by a party opponent, because an 801 answer is better than an 804 answer for purposes of the bar exam. And it's got to be penal, pecuniary, or proprietary. A statement that places them in danger of going to prison, a statement that places them in danger of losing money, or a statement that places them in danger of losing property. The idea being that we won't say things like that unless they're true, because it has a negative impact on our lives. This is a relatively easy one to spot. Where students usually get in trouble when they analyze it is they want to argue that it's a statement, a declaration against interest, when it is actually an admission by a party opponent. And if you'll remember the slides that I gave you at the beginning of the semester where I talk about situating the proceeding and identifying who's who, you should see now how it's even more important that I keep all that stuff clear in my head. Don't worry, we're going to go over it again as we turn our way towards preparation for the exam. Statements of pedigree. If you see a multiple choice question or a fact pattern with an older gentleman who meets a young woman and she's his long-lost child, I can guarantee you that by the end of the question he will be dead. And he will probably die intestate without a will. And if he sees that young woman and goes, "Oh, my baby, my darling, my daughter," that's going to be admissible as a statement of pedigree. Because the idea is we will not acknowledge in public out loud a blood relationship, a marital relationship, or adoption, or some other personal or family connection unless it's valid, because it creates obligations and responsibilities by saying it. And so the thought process is that I would never say it if it wasn't so. So if you're subsequently unavailable, this sort of information will be allowed. I think of this as the, hey, we got to do something with your stuff after you're dead rule, right? And as everybody fights about what of yours should or should not be inherited and who it should go to, this really grows out of fights in intestacy about whether or not someone's statements about their relationship with others should or should not be admitted and understood by the court in determining what to do with property. Relatively simple one. You just got to read to find the relationship. Any questions about 804B4? Cool, good. Those four are the four that I find most common from the standpoint of the application of declarant unavailable. Remember, it's a two-part test. Unavailability being the first part, and then the application of the specific exception being the second part. You should also remember that Crawford has never been applied to an 804 exception. Why? Because the Crawford doctrine deals with the need for confrontation clause in criminal cases. 804, through their historical development as hearsay doctrine, have begun with the concept firmly entrenched that they're much more narrow than 803 exceptions, and that as part of the establishment of their applicability in the common law, we've already considered whether or not there is any need for confrontation, whether there is any value for confrontation, and the determination that there's no benefit from confrontation, and that despite the fact that confrontation is not possible, these statements should still be admitted. And that's a classic example of why Crawford does not apply to 804 exceptions.